yesterday, I believe. They will also be available on the speaker zone on the website in the next day or so. If you are joining us via Zoom, please put your questions in the chat. Be sure and make sure that your name shows up on Zoom as the name that you registered as so that you get credit for attending today. Like I said earlier, we're gonna have door prizes at the end, so please stick around for those and a few announcements. And please contribute to today's flower pot fund, spare change or cash, or you can use the little QR code to donate to Mobile Loaves and Fishes. And with that, thanks so much for coming today. Amber will introduce you.
Okay. All right, Neal. Neal Falgoust is an assistant city attorney for the city of Austin. In that role, he has advised all levels of municipal government on issues related to government transparency, including the Public Information Act and the Open Meetings Act. In his current role, he serves as general counsel to the Office of Civil Rights, the Office of Police Oversight, and the Equity Office, and he advises the city auditor on fraud, waste, and abuse investigations. On occasion, he dabbles in election law and legislative affairs. Prior to the city of Austin, Neal was an attorney in the Open Records Division of the Office of the Attorney General. He's a former newspaper reporter who began his career writing obituaries for the Times Picayune in New Orleans. He's a New Orleans native, right?
I am.
All right. He has a bachelor's degree in print journalism from Loyola University in New Orleans and a law degree from South Texas College of Law in Houston. He's also on the board of directors for Volunteer Legal Services of Central Texas, and he frequently volunteers his time and services at the legal clinics when they were in person and then now online. So if you have any questions about volunteering for volunteer legal services, he can talk to you about what we need and opportunities, not just for lawyers.
As can Amber.
Yeah, I can't do that. Yeah. So anyway, thank you, Neal. Yay!
Hi. And can everyone hear me okay on the microphone?
Yeah.
So good afternoon, everyone. My name is Neal Falgoust. I tend to wander around, so I might come and stand by you. Please don't be afraid of me. I have been doing public information law for about 10 years as an attorney, and then an additional 7 years before that when I was a reporter. And so to me, the Public Information Act is really interesting. Most attorneys hate the Public Information Act because it is very detailed and you can screw up a lot of things. How many of you work for a public agency? Anybody? Nobody's ever, one person has worked for a public agency currently?
Yes. The Court of Appeals.
Court of Appeals, okay. And has anyone ever filed a public information request with a governmental entity? Okay.
Yes.
How did that go for y'all?
It
You
took
got
a
everything you
while.
wanted? You're never gonna get everything you want. So let me give you a little bit of background about the Public Information Act and why we have this thing in the law. So if you go back to the 1960s, in 1966, President Johnson signed into law what is now known as the Federal Freedom of Information Act. That act governs access to records held by the federal government. And it was a compilation of regulations in the Administrative Procedures Act that was all compiled into the Freedom of Information Act. So that was in the 1960s. And in the early 1970s, though, is when it really started to gain steam here in Texas, the movement for government transparency. And that started with the Sharpstown scandal. Has anyone heard of the Sharpstown scandal? A few people, okay. So the Sharpstown scandal occurred in Houston. There was a banker in Houston who was giving stock to members of the legislature. And then the members of the legislature were passing laws that increased the value of that stock. This is highly illegal. And the Securities and Exchange Commission stepped in and conducted an investigation that led to the downfall of several statewide and legislative elected officials. So that was occurring in 1971, 1972, and 1972 was the Watergate break-in. Everyone has heard of the Watergate break-in. So that was occurring at a national level. And really, I think most historians will tell you that the real scandal of Watergate was the subsequent cover-up and not the actual break-in. The break-in was a penny ante, burglary of an office. And what really brought Nixon down was a subsequent cover-up. So in that context, in 1973, here in Texas, we have a legislature that comes into office that is really reform-minded and wants to focus on government transparency and good government. So we get a number of bills that are passed in the 1973 legislature, including personal financial disclosures, campaign finance requirements, what was then called the Open Records Act, the Open Meetings Act, and all of these are found in the Government Code, Title V of the Government Code, which is the Open Government and Ethics section. So what is now the Public Information Act is in Chapter 552 of the Government Code. This is the preamble to the chapter, and it just says each person is entitled, unless otherwise expressly provided by law, at all times to complete information about the affairs of government. So that sounds really, we have all this access to information and everything that's happening about government. But the real meat there is what's in between the commas, unless otherwise expressly provided by law. And that is what allows the government to withhold information from public disclosure. And so as we get into the presentation, you'll see all the ways that the government can use the Public Information Act to not disclose information to the public. So in plain English, what that means is a governmental entity must release all public information requested by a member of the public unless a specific provision of law allows that information to be withheld and the governmental entity has permission to withhold that information. So what is this thing that we call public information? It has a very specific definition under the Public Information Act. And it is information that is written, collected, assembled in connection with the transaction of official business. And it's information that's held by a governmental body, for a governmental body, by some other party, by an individual or employee of that governmental body when they're in their official capacity. And it includes any electronic communication on any device, even if that device is a personal device, if that information relates to the conduct of official business. So let me go through each of these, those first three bullet points in turn and talk a little bit about each one. So information that's held by a governmental body. This is going to be all the information that you would typically think of that's in the file cabinets, in desk drawers, in email servers, all that information that's held by like the city of Austin, right? So millions and millions and millions of pages of information. Second bullet point, information that is held for a governmental body by a third party. Let's say the city of Austin hires a consultant to go out and hire a senior executive, let's say a city manager. And they hire that consultant to go out and collect resumes, interview individuals, compile dossiers on each of those individuals. And that company is a private company, but all the information that they collect is on behalf of the governmental entity. That information is still subject to public disclosure because that private party is acting on behalf of the governmental entity. And the reason that this provision exists is so that government doesn't try to hide information by going out and just hiring contractors to do all of their work for them. Because think about it, if the government were able to shield information from disclosure by just hiring contractors to do their work, they would go out and outsource all of their functions, right? So if a contractor is acting as an agent of a governmental entity, all of that information is subject to disclosure. This causes a lot of confusion by governmental contractors, because one of the things we have to do in our contracts is say, hey, any information that you create on our behalf is going to be subject to disclosure, and you're going to have to release that information. So the third bullet point, any information held by an individual or employee in their official capacity, and if the information concerns official business. So if I am working on something in my office, a legal memo, clearly that memo is public information. It is sitting on my desk and it is held by a governmental body. But if I take that memo home and I put it in my personal file cabinet between my medical records and my financial records, it doesn't lose its character as public information. It is still official city business. It's just stored in a different place. Does that make sense to everybody? It doesn't, just because you move it from one location to another, doesn't change its character as public information. So this becomes important on the fourth bullet point, because if I use my personal email account or my personal cell phone, which the city does not pay for, if I use those devices to conduct official city business, all of that information stored on those private devices is still public information. Just like that memo stored in my private file cabinet is still public information. So does anyone have any questions at this point? I usually stop here to take a sip of water. And also because when I'm giving this presentation to public employees, that last bullet point blows their mind, because a lot of them love to use their personal devices to communicate with coworkers and their bosses, and they just can't fathom how that information would be subject to public disclosure.
So if you have.
I knew there would be a question. See, I've done this presentation for 10 years. I know where the questions come up.
If your personal electronic device has city information on it.
Correct.
Is there a way to protect other information on that device that may reveal, like, the affair you're having with your neighbor's wife?
So for those who are on Zoom, so that you know the question is, if there is, if you're conducting public business on your personal device, is there a way to protect the information about your affair from public disclosure? So it depends. As any lawyer will tell you, the answer always depends. So let's say you are having an affair, and this is not a hypothetical, okay? Let's say hypothetically you're having an affair with someone at work, and that person files a harassment claim against you. That message then becomes public information. And I have seen this time and time again come up in divorce cases where there is one of the spouses is a public employee and is carrying on an affair with someone at work. And those messages and let's say exchange of personal photos becomes subject to disclosure. Yes.
And if the affair has nothing to do with any agency.
Mm-hmm. So if the affair is completely personal and has nothing to do with work, then it's not related to official business. It doesn't touch upon that official business prong of the test. And so it's personal information that is not subject to disclosure. So just like I use my calendar, I use my work calendar in Outlook. I use that to keep track of personal appointments, vacations, therapy. So all of that doesn't relate to my official business as a city attorney for the city. So that is considered private information that's not subject to disclosure. Okay?
So you can have an affair with your neighbor and it be private, but if you're having an affair with a coworker,
Don't have affairs with coworkers as well. If you work for a public agency, don't have affairs with coworkers, which I think is pretty good life advice.
Speaking about all this kind of maybe under COVID, how
Yeah.
people were at home, I mean, did cities provide laptops for people going home and work on their own Dells? I mean,
Right.
and how do you account for that? Like if I'm gonna make a public information request and they're saying there's nothing, I mean, should I say like Stacy County's laptop, or how do you
Yeah.
cover those outside sources
Yeah.
as a requester?
So the question is, with COVID and people working from home on their personal devices, how do you make a request that captures all that information? You ask for it in the request. And my advice is, when you're making a public information request, know what you're asking for. The least effective requests are those that say any and all, blah, 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 blah. So if you suspect that, some public employee is using their personal devices, then specifically say, check on this personal device for information related to X, Y, Z. A lot of requesters, particularly media requesters, think they're gonna pull one over on us by being vague in what they're looking for, and really all they're doing is just being vague. And a vague request is going to get a vague response. So the more specific you can be, the better. Because also, if you're vague and say any and all communications related to the land development code, I mean, that's been going on for the land development code revision has been going on for 10 years. There's millions of emails. We're going to charge you for that. So you're going to get an invoice back that says okay, we'll provide all this information, but it's going to cost you $500,000.
Jeez.
Okay, so public information can take any form, databases, digital photographs, recordings, maps, drawings, emails, text messages, Snapchat, Instagram messages. One of the things we have to advise our clients at the city on is, all those Instagram accounts and Twitter accounts, those are all subject to public disclosure if they are official accounts. Okay. And Snapchat is particularly troublesome because we get into records retention issues because Snapchat automatically deletes stuff. I'm not a Snapchat user. This is what I'm told. So that does get into some problems there. Okay, so the Public Information Act applies only to governmental entities, and that definition is also defined. It is any entity that is supported in whole or in part by public funds. It includes school districts, cities, counties, public utilities, public safety agencies like police, fire, EMS. What it does not include is the judiciary. So that would be district courts, the Supreme Court, the appellate courts, the district courts, and the municipal courts. All of those are governed by Rule 12 of the Rules of Judicial Administration. So if you are trying to get information from a court, that's going to be governed by something different than the Public Information Act. Okay, so how do you make a public information request? This is probably where you all have the most experience. So it has to be in writing. It can't just be a telephone call, call up the clerk's office and say, hey, I want all emails related to Neal Falgoust presentation to the paralegals. It has to be in writing. It has to be submitted in person by U.S. postal mail, fax, or email, and the governmental entity can designate certain email addresses and fax numbers that you have to send that information to. They're supposed to post it on their website if they've designated those locations. So you might want to go on their website, especially like a city or school district, and check to see if they've designated those email addresses or fax numbers. It has to ask for specific information in existence at the time the request is made. So you can't ask for all emails that Neal Falgoust will send on Friday. It has to be already in existence at the time of the request. There are no magic words required, so you don't have to say pursuant to chapter 552 of the government. The governmental entity can provide you a form to collect information on, your name and where to send the information, but they can't require that form. So if they give you a form and you say, no, I want to write it on a napkin, and here's my written request on a napkin, they have to accept it. And when I was a reporter, I made several requests on napkins because I'd be standing there in the clerk's office and they'd say, oh, go ahead and give us a public information request. So I just pull out like a piece of paper that I had in my pocket, and stretch it down. It does not include questions or requests for legal research. So if you write down something like, what is the reason the cop gave me a parking ticket? That's not going to be a public information request because that's a question, okay? And once the entity receives the written request for information, they have to make a good faith effort to relate it to information that's in their custody. So a good faith effort is not every effort. It's only a good faith effort. So they don't have to go to the ends of the earth to find the information that you're looking for. All they have to do is make a good faith effort to search for the information. So that's why I say be specific about the information that you're looking for. If you can give the names of the person who sent the email or the person who holds the records, even a department, that would be helpful.
So City of Austin has a thing, right, on their website. I think I've used that to submit it. So it's real easy.
Yes, a lot of governmental entities are going to this online portal called GovQA, which is a system that allows us to track all of the requests that we receive. On the front end, it's very customer friendly. You create an account, you submit your request, and then it gives you a tracking number and you can monitor updates. On the back end, it allows us to farm those requests out to all of our departments. Because every request to the City of Austin comes through one central database, and then we farm it out to all of the different departments, and we have about 60 departments. We have 14,000 employees. It's a big organization. So in your request, if you can put like, we want the information held by Austin Energy or Austin Police Department, it helps us target those departments. Because again, we're going to make a good faith effort, but not every effort. I mean, we have thousands of these requests to process every year. We can't go like looking under every,
So my request I talked about earlier, where I want to get arrest records from 1971. Is the APD going to make a good faith effort to go find it in the box? It's probably not scanned or.
So I don't know how APD handles all of that. If it's a major, like if it's a murder investigation, it probably is still subject to retention. If it's like a petty theft, my guess is the records from 1971 have been destroyed.
Well.
Yeah, I mean, we have huge warehouses of paper and.
Do y'all go and look for that one piece of paper that we're requesting?
If we can.
Or you're like.
We might charge you for it.
Not your hourly rate.
It's usually about $15 an hour.
Okay.
Yeah, and believe it or not, digital records are more expensive to maintain than paper records. So when people say, oh, just scan it and store it electronically, that's actually more expensive to us than it is to just take a piece of paper, put it in a box and send it to a warehouse. Okay, so now that we have gone over these tips for how to make a public information request, we're going to look at a few examples, and we're going to decide if these are legitimate public information requests. Okay, so pursuant to the Public Information Act, the First Amendment to the U.S. Constitution, and the Freedom of Information Act, I request a copy of Amber Haney's annual employee evaluation and records of her salary. So we're going to assume that Amber is an employee of the City of Austin. Okay. So is this request made in writing?
Yes.
Yes. Does it ask for specific information in existence at the time of the request?
Maybe.
Yes.
She's a little defensive. But information may not be available.
It doesn't say what year.
That's a good point. I might put in a year. That might narrow it down.
Yeah, what if I've been there forever?
Yeah, I mean, that would be a lot of, if you've been there for 20 years, that would be a lot of information. So we might respond and say, we have 20 years worth of information. Is there a specific year that you're looking for? We're allowed to respond back to the requester to try to clarify or narrow the scope of the request. Okay, so yes, this is a valid public information request, and I just put it in there to show you don't need to use all that superfluous language. For some reason, and I don't know why, we get a lot of requests that cite the First Amendment to the Constitution. It just sounds good to a lot of people, the First Amendment, but it really has no bearing on this at all. Okay, so here we've written down a request on a sticky note. Give me a copy of report number 17-61859. Is this request in writing?
Yeah.
Yes. Does it ask for specific information in existence on the date of the request?
Yes.
Yes. Now, it might need some clarification. Is this APD report, AFD report, code inspection report? So we would respond back and say, hey, what report exactly are you talking about? But for purposes of triggering the Public Information Act, this is sufficient. A customer calls your office asking for the name and title of each employee in your office. Is this request made in writing?
No.
Nope, we stop right there. This does not trigger the Public Information Act.
So you hang up on them or?
So, see, now, this is how often I've given this presentation. My very next sentence is, that doesn't mean you hang up on them. You still have an obligation to provide good customer service, right? So you might ask the person to submit a written public information request, okay? Amber, good customer service. Please provide me with a copy of all emails between Neal Falgoust and Amber Haney beginning tomorrow for 3 days. Is this request in writing?
Yes.
Yes. Does it ask for information in existence at the time of the request?
No.
So this does not trigger the Public Information Act, and there is no need for the government to collect that information going forward. Now, after 3 days, the person can write back and say, hey, give me those emails for the past 3 days, and then that would be valid.
Could they get the emails that I wrote to you from my Gmail on the work computer?
Yes,
That's where
because
we
they're
talk
gonna
about,
be, so anything you send to me, to my austin.texas.gov email, if it is work related for the city of Austin,
Okay.
then it is subject to disclosure. Yes. If it's
If it's
Amber,
the
if
video
you're
of
just,
us doing karaoke
no, that's not
where we
work
won that
related.
competition.
Yes.
True story.
She doesn't mean like a virgin when she's 7 months pregnant.
Only what
Can I request video of that?
It's on my computer, so. Okay. Yes. What is the city's authority for telling me I can't cut down my tree? It's my property and I can do what I want with it. Okay, is this request in writing?
Yeah.
Yes. Does it ask for specific information in existence at the time of the request?
Yeah.
Yes.
We have some, it's legal research.
Yeah, that's what-
We have some, it's a question. We have some, I don't know. So I put this in here because it's unclear, right?
Yeah, it's tricky.
So I would probably say that it has not yet triggered the Public Information Act. But what do we like to do, Amber?
Good customer service.
Good customer service. So I would probably reply back to this person and say, hey, are there specific records that you're looking for? We don't answer legal questions. So that is sort of how I would handle it.
If they're asking for like the city ordinance, is that research? Are you saying that if you're not producing anything that says what the laws are?
So in my response back to them, I would probably say, do you just want a copy of the ordinance?
Yeah.
Like, that's easy enough to provide, like,
Okay.
you know, all that's online, we can provide them a link to the ordinance.
Or are you looking for the,
If they're
ticket we
looking,
wrote
they
you.
might reply back and say, oh, well, I want the legal memo that the city attorney sent to the, you know, tree people that said I couldn't cut down my tree and stating the legal analysis. That would be something different. We'd handle that in a different way. Okay, all right. So like I said earlier, emails and faxes are considered public information requests, but the governmental body can designate a specific location for those to go to. So make sure you're sending them to the right location before you send it. So once the public information request comes into the governmental entity, that starts certain obligations on the government's part for providing a response. So the government cannot ask you why you want the information or what you plan to do with the information. You can throw it in the trash can, you can set it on a bonfire, you can publish it in a paper. Once you have it, it's yours to do whatever you want. The government can ask you to provide contact information because if we need to reach you to clarify the request or to provide the information to you, we need some way to reach you. And as I mentioned earlier, we can ask you to clarify or narrow the scope of the request. And that's just so that we can get a better idea of what it is you're asking for and so that we can provide a better response. So we have two options. Once we've determined that there is information that's responsive to the request, there are two options. We can provide the information promptly, or we can seek a ruling from the AG's office that would allow us to withhold the information from disclosure. So either prompt release or withhold from the Attorney General. Not surprisingly, promptly is actually defined in the Public Information Act. It means as soon as possible under the circumstances within a reasonable time and without delay.
a lawyer wrote that?
Does that clear it up for everyone? Okay. So if the information cannot be made available within 10 business days, that's 2 weeks on the calendar, assuming that there's no holidays, we have to notify you of a specific date and time when the information will be made available to you. But going back to the promptly, what that means is, and this is what I tell our clients, if the information is sitting on your desk in front of you, promptly means like right now. If you have to go out and compile, you know, pages and pages of information, hundreds of pages of information, and you have a city council meeting to attend that day and you're preparing for other meetings and just have a lot going on, promptly might mean like a week or two. It might take you to get that information. If we decide that the information that's been requested, we want to withhold that information from public disclosure, we have to request a ruling from the Attorney General's office that would allow us to withhold that information. So we have to write a letter to the Attorney General's office within 10 business days of our receipt of the request. 10 business days, again, is 2 weeks on the calendar, assuming that there's no holidays. We also have to provide a legal brief, you know, a brief-ish explanation of why we want to withhold the information. And then we have to send copies of those letters to the person who has requested the information so that they have an opportunity to respond to the AG's office. We're going to count to 10. Can everybody count to 10? Okay. So when counting business days, you start counting the first business day after receipt of the request. So if the request comes in on Monday during business hours, day number 1 is Tuesday. Weekends and holidays don't count as business days. It's not surprising. And bad weather days when we're closed or other emergency days also don't count. So when the city was closed in February for Winter Storm Uri. I think we were closed down for a week. None of those days counted for business days because we were closed. And then there are also, you know, small cities and towns that have these weird holidays, you know, like Chicharrones Day. So there are those days they have to tell, you know, it's not obvious, but they have to let you know when those days are. Okay. So here is a calendar for the month of November. We're gonna count to 10. We're gonna figure out when is the deadline for the city to notify the AG that they want to withhold information. So the request comes in at 5:15 p.m. on Monday, November 2nd. So when do y'all think the 10th business day will be?
The 8th.
And how do you, okay, for the 23rd, how do you get there?
Yes.
You act
Yeah.
like it's received on the 13th,
Okay,
and 4th, 5th, 6th, 9th, 10th, 12th, 13th, 16th, 18th, and then we're going.
okay, okay. What do you think about it being received after 5 o'clock?
What are your business hours?
Oh, yeah.
Oh, 5 o'clock, 8, yeah, 5 o'clock, sorry. I assume that, yeah. So we close at 5. I mean, I stay till 7, but.
So I start on the 3rd.
So it's deemed received on the 3rd.
That's not day one? You start
Day 1 is the 4th.
Oh, I thought the 3rd was day.
Skip Veterans
Me
Day.
too.
We had a bad weather day, then we had Thanksgiving, 23rd.
Alright.
There you go.
What
So-
happens if you don't make the, I mean, who's holding you accountable? Do you have to pay us?
See, I've given this presentation a lot. Okay, so
make sure
if
you're
we
helping.
miss the deadline, there are certain legal exceptions, there are certain legal arguments that are taken off the table for us immediately. And we waive all of those exceptions. Also, there's possible exposure to a lawsuit. Once those, well, actually, the possible exposure to a lawsuit starts on day 1, honestly, but it increases when you pass the 10-day deadline. Enforcement action by the Office of the Attorney General, and then just a negative perception by the public. Every reporter that files a public information request knows when day 11 is. And if they haven't heard back from us on that day, I guarantee you we will be receiving an email from them asking where their information is. Okay, so here are all the, well, not all of them. Here are some of the reasons that we can withhold information from the public. There are thousands of these types of exceptions. The AG's office has a binder that's very thick with all of the statutes in federal and state law and court law that provide ways to withhold information. So 552.101 is the statute that pulls in all those confidentiality provisions that are found outside Chapter 552 of the Government Code. So things like the Health and Safety Code, which we used a lot during the pandemic, all sorts of exceptions in federal law and in state law and in common law. So 552.101 acts like I describe it as a pair of handcuffs. You attach other statutes and other confidentiality provisions to 552.101 to bring it within the purview of the Public Information Act. 103 relates to pending or anticipated litigation. So let's say you file a lawsuit against the city of Austin for somebody, your client slipped and fell at the airport. You file that lawsuit on Monday, and then on Tuesday, you file a Public Information Act request for all the information related to your client's slip and fall at the airport. So at that point, we already have pending litigation because you filed a lawsuit, and we're going to use this exception to withhold all of the information through the Public Information Act. The reason we do that is because we want to force you into the discovery process. We don't want you to go through the public information process to get that information. We want to do it through discovery. 104 is our purchasing exception. So when we are going through the purchasing process and negotiating contracts, we use that exception to protect our negotiation interests. 106 is internal drafts and working papers related to drafting new ordinances and other legislation. 107 is the attorney-client privilege. So anytime we are communicating with our clients or sharing drafts of legal documents, all of that information is protected under the attorney-client privilege. 108 protects law enforcement records related to pending criminal investigations. That's because we don't want information related to our investigation to get out into the public because it could affect the investigation or provide confidential information to witnesses before we've had a chance to interview them. 111 protects opinions related to policymaking. So anytime we are exchanging thoughts about, implementing, let's say the camping ban that's been hot lately. So let's say we're exchanging ideas on how to implement the camping ban. That's all privileged under 111. Let's see, 116 is what our auditor uses, our auditor's office, to protect all of their investigative documents and their audit working papers. The final audit that results from those working papers is public. It has to be disclosed, but all the work that went into that audit is protected. 117 protects employees' personal information. So like in our personnel files, our home address, home telephone number, social security number, family member information, and emergency medical information is all protected under 117. 130 protects motor vehicle information. So VIN numbers, license plate numbers, registration documents are all protected. 136 protects bank account, credit card, debit card numbers, frequent flyer, hotel rewards numbers. 137 protects personal email addresses. I have an asterisk there because if you use your personal email to conduct official city business, it is no longer protected. That email address is no longer protected under 137. And 147 protects the social security number of a living individual. For some reason, if you're dead, your social security number can be released because 147 only protects it if it is a living individual. Sometimes, especially in the purchasing environment, we take custody of all these proposals that have been submitted to the city in response to RFPs. Once those proposals are submitted to us, they become public information, but they relate to business operations of private entities that want to do business with us. We typically don't object to releasing that information, but those businesses probably do object. And in that situation, they are allowed to brief the Attorney General's office on why we should withhold that information from public disclosure. And you use 552.110. They use 110 to protect all that information.
What about in the situation where they're trying to protect the bid itself, the numbers in the bid?
So for bidding information, once the contract is awarded, a lot of that bidding information becomes public. During the negotiation process, the city will usually use that 104 exception to protect that bidding information, because from our perspective, let's say we've received all these bids, we've selected a winner, we're in the process of negotiating. If that negotiation fails and we're not able to sign a final contract, we want to protect all of that negotiation so that other bidders in the future, when we relet the bid, don't have that, don't see our negotiating position, essentially.
It's closed.
Once the bid is closed and we've signed a final contract, the city releases a lot of that information, unless the third party objects. So,
And then
here's an
that's the
example.
OAG for it, too.
right, so here's an example. Let's say we get 3 bidders that submit pricing information for widgets. We select a contractor to provide the widgets, and we execute that contract. The person that we are contracting with for those widgets, we will release the pricing information because that is highly public information. The public has a high interest in how much we're paying for widgets. But for the 2 losing competitors, they aren't going to want to show the public their price information for widgets. So they would be able to object to that release. Does that make sense?
Is it, can you tell us what kind of exceptions are automatically knocked out if you miss that 10-day? Is it?
Oh, yeah. So the ones that would be automatically knocked out would be 103, 104, 108 in certain situations, 111, 116. Those would be the big ones.
All right.
So those are only protected for like 10 days.
Yeah, that's why we have to act fast. 107 used to be waived if we missed our deadline. And then the Supreme Court stepped in and said 107, the attorney-client privilege is of such monumental importance that it can't be waived simply by missing a deadline.
So if you, like, I'm thinking of a criminal request that I made. They eventually came back and said that they had made a ruling and weren't giving it out. Feels like it took a lot longer than 10 days, but I don't remember.
The ruling process?
Yeah.
Yeah.
So they have to, within the 10 days, say, hey, we saw your request. We'll get back to you when we know what we're gonna say to you.
Let me answer that on the next slide. So yeah, the next slide. Once we make a request to the AG's office to withhold information, the AG's office has 45 business days to issue a ruling. So that's 9 weeks on the calendar.
You have to tell me that you're doing that prior to the expiration of the 10 days.
Yes, within the 10 days, we have to tell the AG and you that we are withholding information. Once the AG receives that letter and their process, then their clock starts to tick and they have 45 business days. So we are now so let's say we go to the AG for a ruling. You've got, and assuming that there are no holidays or anything else, you've got the 2 weeks for the 10 business days. You've now got 9 weeks for the AG ruling process. So we're up to 11 weeks on the calendar.
And then
It's going to get longer, by the way.
And then what's your deadline to file your response to the AG's ruling request?
For the requester can file a response with the AG at any time during the process. It's better to do it quickly than to wait, because if it's an easy case, if it's an easy question, the AG is gonna get it out as quickly as possible. There is a triage process at the AG's office. And so every file, when it comes in, gets reviewed to see how complicated it is. And if it's an easy one, they'll turn it around within a week. If it's a complicated one, then it goes to an attorney for drafting, review, and all that.
If there's a third party that's involved in the request, like in going back to the bidding process, where you have lots of different companies, when the request goes in, does the entity, the governmental entity automatically include all those people?
Yes. So for third parties, the way it will work is we have an idea that the third party objects to releasing the information. We send a letter to the AG. We send a letter to the requester. We send a letter to all of the third parties. And the third parties then have to brief the AG separately. We send all those letters at the same time within the 10 business days. The third party, once they receive their notice, has another 10 days to contact the AG's office. Okay, so 45 business days, the AG should issue a ruling. They have the opportunity to extend that by an additional 10 days. So that's another 2 weeks. So we're now up to 13 weeks, okay? The outcomes for a ruling: must withhold. So the AG might say, governmental entity, City of Austin, you must withhold this information. That means that there's a confidentiality provision at stake, and the city has no authority to make a decision to release that information. May withhold means that they are granting us permission and is within our discretion to decide whether we withhold or release it. So those exceptions that can be waived, the 103, the 107, the 111, those are all discretionary exceptions, and we can choose to at some point release that information if we want to. And then the AG can say, City of Austin, you must release this information. That means that we did not provide sufficient legal reason to withhold the information, and we have to release it to the requester. There are certain types of public information that are of such high public interest that they generally cannot be withheld from disclosure unless there is a very specific confidentiality provision that applies. So completed reports, audits, investigations, or personnel evaluations generally need to be released. Police investigations in some situations can be withheld, like I said earlier. The name, sex, ethnicity, gross salary, title, dates of employment of each employee. Has anybody ever gone on the Texas Tribune Salary Explorer?
Yeah.
Yes, that is the most popular database. I've talked to the people who run that database at the Texas Tribune. They track where their traffic is coming from. Guess where it comes from? Governmental entity servers, right? So all the governmental employees are checking their coworkers' salaries. So there was someone, the Texas Tribune used to send a request every year to the City of Austin to get this database. I guess it became too much work for them because they haven't done it in about 3 or 4 years. Now they only focus on state of Texas employees. And that's because they can just go to the comptroller's office, and the comptroller is the agency that has all of this information. So they get it in one big data dump and post it online in a very convenient database. But you can, if you want all this information for the City of Austin, you can make a request. And that is something that we turn around fairly quickly because it's easily accessible in the database. Information related to the receipt or expenditure of public money. So I think the City of Austin has a check database online where you can go and see all the checks that we have written to vendors and all those sorts of people. Information contained in an attorney fee bill that is not protected by the attorney-client privilege. So you all probably prepare the attorney fee bills, right, for your offices. So generally what's going to be disclosed is the number of hours worked and the billing total, and the information that can be withheld would be in the description, because that is usually the attorney-client privileged information describing the services that have been provided. And a settlement agreement, a legal settlement agreement to which the governmental entity is a party. So if we're sued and we reach a written settlement with someone, that information has to be disclosed to the public. A lot of times, lawyers will try to put in a confidentiality provision into a settlement agreement. That provision, if the other entity is a governmental body, that provision is void, and it will have to be released if requested. So if you're ever settling with a governmental entity, just keep that in mind. There are certain specific situations where we can withhold information without going to the AG's office. These are called previous determinations. These are authorized by statute and by previous rulings issued by the AG's office. I won't go into too much detail on these. Civil penalties and criminal penalties are available under the Public Information Act if the governmental entity fails to comply. On the civil penalty side, the requester the county or district attorney or the office of the attorney general may file a lawsuit for failure to comply. In those situations, the court is required to award costs and attorney's fees to the prevailing party. So the trick here for the governmental body is that if we release the information before a final judgment is entered in the lawsuit, then we don't have to pay any of those costs because the other party is not considered to have prevailed. So there have been a few times where we've been sued and we have decided for our own financial reasons to just go ahead and release the information to short circuit this provision so that we don't have to pay litigation costs and attorney's fees. Criminal penalties, it is a misdemeanor offense to outright refuse to comply with the Public Information Act, to distribute confidential information that you know is confidential, or to willfully conceal, destroy, or alter public information. So we tell our staff all the time, don't fire up that shredder when you get a public information request because that can be a criminal penalty. Any questions?
So is there any policy about when to file a request for ruling? I feel like anytime that there is one, it's filed on the 10th day.
Yes.
It's like there's end of statute.
Look at it from our perspective.
We busy.
So we have 2 attorneys and a paralegal who are doing all these ruling requests. And so let's say a request comes into the database. That whole processing is handled by a different team. It's not handled by the legal staff, it's handled by non-legal staff. So they get a request, they farm it out to the departments. The departments then have to go and gather information, review it. Then a lot of times, most of what the attorneys do is answer questions from the departments about, can we withhold this? And if so, there's all that discussion that takes place. We are honestly very lucky to be able to get everything out by the 10th business day, once all of that occurs. For a smaller organization, it might be a little bit easier. And in situations where we know there's a high profile request coming in, we'll try to turn it around a little bit quicker, especially if it's media, just because we don't want that bad reputation. We want to do it as quickly as possible. But for the most part, it's going to be 10 business days.
So you're speaking from working at the city of Austin, right?
Yeah.
I gathered that. from
Yes,
everything you
yes.
said. So, and that encompasses like a lot of different departments, based on what you just said. So what other avenues might I be requesting information, like the DPS would be another agency, or like old judicial records is a different process, you said?
Yeah, judicial records or records held by a court, you're going to go directly to the court clerk, and that's going to be Rule 12 of the rules of judicial something or other.
Okay, so if I wanted to find a DBA, that would be Public Information Act?
A DBA would probably be Secretary of State's office, and a lot of those are filed online. Here's the other thing. Google is your friend. We get all kinds of requests, especially from media, I have to say. This isn't going to be made public, is it? Especially from media. It's like, did you even bother to go onto our website and type in what you're looking for in the search function? Because we have so much available online that a lot of times, if it's just basic stuff like DBAs and publicly filed documents, a lot of that stuff will be available online. And it's going to be quicker for you to get it online than to file a public information request.
And also like CPS reports, if you're in the law case, would you use the same process and just find out what local division of CPS you need to contact?
Yes, if there's a investigation, if there's a police investigation, you might want to go directly to the investigating authority. CPS cases are tricky because there's a provision in the family code, 261.201 of the family code. Sorry, I've been doing this for a while. 261.201 of the family code governs access to child abuse investigation records. And it's a very, let's say, complicated statute. So you'll want to take a look at 261.201 of the family.
261.
261.201. Yep.
She's gonna check Cedar to spit now.
And juvenile records, if there's a juvenile involved in a police investigation, that's going to be 58.007 of the family code.
Yeah, that's your family code.
So is all of your personal information protected on, like, through all the, you know, like, if I just have to get on because I'm.
You can Google me.
Like, are there levels, I mean, people always hear like Judge Byrne, for instance, you know, we wouldn't be able to look up her home address.
No.
That sort of
No.
stuff is
Right, yeah,
protected,
yeah,
right?
yeah.
Find out where she lives.
I mean,
Is that?
unless you go into like the Travis County tax records, yeah, appraisal district, yeah. I mean,
So they don't universally protect the government.
so for the tax office and the appraisal district, there's a form, I think, that public officials and judges can file to close down those records. But it requires them to take that action. But, you know, so if you're trying to find out where someone lives, like an elected lives, you can always go to the, either their campaign finance reports or their candidate filing documents, and usually that's where you can find information. So there are always loopholes and tricks to get around it. Yeah.
What if you want to investigate a personal injury case, a car accident? So you want to get a crash report and maybe some.
Just call the legal connection.
CR3.
They're a legal vendor that can
Oh.
request records for you.
Oh, really?
Yeah, there's a lot of stuff available on LexisNexis. LexisNexis is one of our most frequent requesters, by the way. So CR3 crash reports are considered public information. There might be some pieces of information within the report that are confidential, but the CR3 crash report form is considered.
That was my next question, because if you have a 16-year-old driver who's a juvenile, who was involved in a car accident.
A traffic violation might not be considered a law enforcement record under 58007. It's been a while since I've looked at that, but I think just a traffic violation might not be protected.
So in the case where.
Unless they've been like charged with, you know,
If it's
vehicular homicide.
Yeah, so there's two different parts, right? So there's a wrongful left turn, and that's the traffic violation.
Right.
But it also results in a death, which is
Yeah.
another case.
That might be, there might be some special considerations.
So you might be able to access. the
You might be
legalities.
able to access like CR3, but not the investigative report. Okay, I understand that there's a drawing. That everybody, that's really the reason you're all up here. So I will step aside.
Keeping it.
Very much.
And we have surveys on your table if you want to complain or.
I would appreciate 10s.
Before we get to the drawings, I would just like to remind everybody that we have extended the deadline for the Paralegal of the Year Award. Don't think you have to be a super woman or super person to be nominated. We have $500 cash award for somebody. We all do really hard things every day, and we're all really busy, juggling a lot. So think about a friend or a colleague that you might nominate. They do need to be a CAPA member. We also have the Susan Haney grant application that can be applied for or not, or you can nominate. Again, it's hard to live up to Susan Haney and all that she did and accomplished in her life. But if you aspire to do that, or if you know somebody that's doing really good things, take the time, check out our website, It's on our social media. I'm sure we've inundated you with emails about it as well, but check it out and consider applying or nominating someone. The deadlines for both, one paralegal of the year is November 30th, and Susan Hayes is, I believe it's December 6th. It's on the website. Also, we have our holiday party, December 16th. Information will be going out about that. It's going to be at Hilder's house. Our social committee is planning lots of fun for everybody. There will be karaoke. Sorry?
Is it for just members or can we bring?
It's members, and I believe guests are allowed.
Yeah,
for,
yes, I think there
a
might be.
small fee.
Yeah.
For a small fee. They're finalizing all of those details. As with all good things in COVID times, it's been challenging to get all of that finalized. If anybody's interested in volunteering with CAPA, we have a volunteer session tomorrow at noon. Please join us for that. No pressure, just learn about what opportunities we have. And we have no CLE in December, but in January, we will be going back to completely in person.
Yeah.
We will not be offering Zoom attendance, but we will be offering the recorded version. And with that, Celeste will do some draws. Oh, and you're going to do some draws. Amber,
Oh, sorry.
thank you.
I got distracted.
Okay. A few prizes real quick. Actually, your sustaining member spotlight. Brian, do you want to get up and say something about Razzie? Razzie Dazzy?
Hi, everybody. Good to be back. I haven't been to a live event in a while, so it's really great to be here. We do corporate. We're not on the evil litigation side. So if anybody needs, office deals, deformations, registered agent, give me a shout. Take your care. So we're the corporate division of a litigation company.
All right.